Perfect. Now it's yours.
Okay. So today we're just going to talk about, I think the last time there was a lot of information, and I'm going to try to just do this in a little bit more condensed so it's not so overwhelming for you. But again, you can go back and read it. I wanted just to talk about some of the do's and don'ts that you want to have and take into consideration when you're representing a client. So let me see. This is what we're going to cover, just the common violation and trends, and this will come from the Division of Real Estate, and then how to reduce your risk practices. So those are the two things that we're going to cover today. So license law enforcement, you have a complaint and an investigation process when a complaint is filed against you. And so we have to always know kind of where that is at and who has the authority to oversee that particular complaint. So there's always things that are in violation of the code of ethics, because we are a member of the NAR and we are a realtor. So you have the complaint process, which could be made at the local board level, which would be a violation of the code of ethics. If they get something in the grievances department, they will look at that and see it, make sure they have jurisdiction over that and they can handle it. And if not, then they will recommend that that be taken and put at the Division of Real Estate. So who has the jurisdiction when a complaint is filed? The majority of the time, you are in violation of the code of ethics. So most of the complaints stay at the board level. And now that board is no longer, like the Cincinnati Area Board is no longer just handling those grievances and hearings anymore like we did in the past. That's now going to be done on a state level. So now the state of Ohio is at the Ohio Realtors is going to be handling those board complaints. And there are people from all over. I sit on the grievance committee and I sit on that hearing committee as well. So there are people from different areas of the state that are utilized for those, since there are different practices within each part of the districts. So you have mediation, always an option. If you ever have a complaint that is filed against you, make sure that you ask for mediation, or that your broker manager asked for mediation. So if you ever have a complaint, you're going to come to Jeremy, myself, or Ron. We're going to talk about that, and we're going to always have you recommend mediation, because at that point, we are going to try to assist you in that. So that's always an option, but a lot of people don't request that. They don't realize that is an option. And then if you move on, you go into a hearing process, and then depending on what is found out in that hearing process, the Ohio Realtors or the board and committee can issue penalties and fines. And then if they find something else out that needs to go into the Division of Real Estate, then what is that? So that would be license law. Anything that is violation of license law would be handled by the Real Estate Commission. So those are kind of the order of the complaint and the investigation progress. So the biggest complaints right now at the Division of Real Estate are your property management violations, agents managing in their own name. So you cannot, as a real estate licensee, manage a property for a client in your own name without the explicit understanding and agreement of Jeremy. And I would tell you, I don't know if he's on this call, but I would tell you, we have a property management department, so he would refer you to the property management department. He is not going to want agents managing properties in their own name. That does not apply to your own property. So this is just, you're taking on a client and you're going to manage that client's property. That's a discussion you need to make sure you have directly with Jeremy on how he would want you to handle that. But I guarantee you, he is going to probably refer you to the property management department, as we have that. Second or third, granting unauthorized access to properties. This is a huge complaint. Agents giving codes to potential buyers to look at property when they can't go to a property, and that is a violations of license law. It is access to the property is not permitted. So that is still a high complaint. Failing to reduce agreements in writing. Agents kind of having agreements on the side with other agents or whatever, and nothing being in writing. That is another complaint. earnest money and trust accounts, and then video and photography without consent. So those are the most common violations at the Board of Real Estate, as well as the local board here. The most common complaint is fraud. That is the first thing that is typically brought up, and that is a misrepresentation, whether it be by the agent or by the buyer or seller, non-disclosures of items and concealment of issues. So that is the most common complaint. So you need to know what the elements of fraud is, which is misrepresentation of concealment of material fact. If you knew it was false or acted with utter disregard as to whether it was true, intent to mislead someone to rely on it, and other parties did rely on it and damages were suffered as a result. So that is also a very good kind of bullet point that you can share with sellers when they ask you, what should I put on my property disclosure form? This elements of fraud would be a really nice bullet point for them to have, so that you can say, well, if it falls in any of these, then those are the elements of fraud that we need to avoid. So when someone, I always use an example of, I got this bookends for my niece for her birthday one time, and she was into books, and I painted it. It was kind of at a craft show, and I took it and I painted it, and then I gave it to her with a bunch of books for her birthday. She was like 4, and everybody was there, and they said, "Oh, did you make that?" And I just was like, "Yeah," because in my mind, I painted it and I created it for her. But then I started, like, this is my compliance thing coming out in me at a young age. But then I start questioning myself, like, I don't want them to think I actually created and built this. So I had to go back and say, no, I didn't make it, but I painted it, I bought it. And I had to over explain that because I was so afraid somebody would think that I misrepresented that. So it's things like that. If you think that if you're saying something, it's like our parents used to say, but lying by omission. But if you know that someone believes something to be true and you don't correct it, and they're making decisions based on what they're thinking, and you know that it's not right what they're thinking, then you need to correct that. As is clause defenses, they're commonly used in purchase contracts. It protects the sellers from claims of fraudulent non-disclosure as long as the seller didn't make any false statements and the seller didn't engage in concealment. So this is the same kind of scenario when you have the seller fill out the exempt form for the property disclosure. That exempt form does not exclude them from disclosing things if they know that there are things on there that they need to disclose. So just because they don't they haven't never lived in the house or anything like that does not mean and preclude them from actually making a disclosure if they actually know about it. I keep having to, okay. The real estate license law provisions, only liable if you actually have not, so this is going to apply to you. You're only liable for fraud if you have actual knowledge of something. It can be inferred as if acted in reckless regard. But remember that you are not required to discover defects. So when you go on these home inspections, don't be looking for issues. Let the inspector look for issues. You're not required to discover the defects. By the open eye, if you're walking around and you see something, you see a water leak, you see something like that, that's one thing. But don't go searching for defects in the home. You're also not required to advise on matters outside of your scope or license. I'm going to change that. Don't advise on things outside of your scope of practice of your license, because that is practicing without a license and it typically goes into a legal matter. So don't advise on things that you are not capable of doing. I've been in inspections where an agent will go, that looks like, the foundation has slipped, and let that come from an inspector. Don't give your advice on things like that. You can say something, another way to say that is that floor looks a little uneven. When we have an inspection, we need to make sure they look at that. And then you're not required to verify the accuracy of the seller statement. So that is why we don't help the seller complete the property disclosure form. We tell them, one of the ways that I've always instructed agents to do it is when you go around and make your measurements of the home and kind of take the assessment at the listing, you hand them this 5-page agreement and you say before you hand it to them, look, I'm going to give you this property disclosure form. It is a state mandated form. It is 5 pages. And I need you to complete every question on the form to the best of your knowledge. And if there comes something on the form that you wonder, should I disclose this? Then I'm going to tell you, yes, you should disclose it. If you have to ask me, then you should. I can't help you fill it out. So the best practice is to say, if there's a problem, state the problem, state how you fixed it, and that there's been no problem since, or there is continual problem there. And that's the only thing I can tell you about the property disclosure. So that's kind of the language that you would want to use with them. You can't help them write it. You can't give them suggestions on how to write it. You have to let them do it on their own. So make sure that you are having the conversation prior to handing it to them so they understand what they need to do. And then you have the stigmatized properties, which includes murders and suicides, off-site conditions, the Megan's Law, seller consent to disclose. So you cannot disclose if a property has had a suicide in it or a murder in it, or if there is a sex offender living beyond 500 feet of the property. You have to have the seller's consent to disclose any of that. It is a wise decision to tell the seller that of their rights and what the pros and cons of doing that could mean. So there are some people that have a heavy thought process when it comes to murders and suicides in a home, and they will just avoid the home. And then there's others that don't care. There's some people that search them out. So there's all kinds of people. But if they don't disclose it, they need to understand that when there is a inspection and the buyers are present, somebody's probably going to tell them. So whether it be a neighbor or whatever, they're going to probably tell them. So it would be better to disclose sometimes in the beginning if they're going to disclose. And if they're not, then they just need to, make that decision. But you have to have the seller's consent to disclose those kinds of things. Now, if there is a 500, I think it's 500 feet, might be 1,000 feet now. They're going to have to disclose if somebody has moved next door to them, because I believe there is a form that is sent to those properties. And at that point, that's a disclosure item that would affect the home. But just because somebody lives in the same neighborhood, that is not part of that. So make sure that you just give the resources for the buyers to look up their own information. Any questions, Wayne, before I move on?
No, I think we're good. All good stuff. Like it's just for me as I'm sitting here listening, and I'm looking at our group here. So we have some experienced agents, some new agents. It's always interesting to either possibly learn it for the first time or hear that, even if you're a new agent, you probably, in the course you heard some stuff and studied, whatever, but I appreciate just hearing it. This is a good way to, to handle this, or so I think it's great. So.
Okay. The other thing you need to really pay attention to is the do not call. Make sure that you are checking that before you reach out to people. I know a lot of people are starting to go after like some FSBOs and some expireds. So just make sure that you're checking the do not call. Here is the quiz on whether or not you should call them. Is the listing agreement should include permissions from the clients to call them, which they do. No calls before 8 a.m. or after 9 p.m. If I call a FSBO for a listing, I must check the DNC registry. That is true. Best practice would have to be an open house. Sign-up sheets include a statement that permits agents to follow up. So, I believe we have some in Agent Hub. If not, they'll be added to the buyer folders that we've created that I'm getting ready to upload this week. But anything on an open house, you should say, if you're not represented, may I, the signing this piece of paper allows me to follow up with you, something along those lines, so that you have their permission. And if I call a FSBO for a buyer client, I don't have to check the DNC, but not to solicit the listing. So if you're calling a FSBO and you're just calling to try to get the listing from them, then you have to check the DNC. But if you are calling them because you actually have a buyer, and don't call and say, I have a buyer, just because you want to get in front of them, and then no, all of a sudden the buyer goes poof. But if you actually have a buyer and you're representing them, and this will come into play when we bring in this buyer agency agreement, that you'll have a buyer agency agreement. That will be a checkpoint for the division to make sure that you actually had one, timestamp and all. So make sure that you have that, but you cannot solicit the listing when you have that. And here are the resources that you need to check. There are several do not call lists that are out there. So to check to see if your number is listed, there is a website for it. You might want to take a screenshot of this or look at it on replay. To register a number on the do not call list, that is where you will go. And that's gov, not GOVE. I need to change that. The FTC homepage for do not call and the FCC home. Those are both of those lists that you need to check to make sure that the person that you're getting ready to call is not on the DNC list. So let's talk about love letters. It was just Valentine's Day, right? So let's talk about love letters. Love letters is the letter that a buyer wants you to submit with their offer to the seller. And it is important to know that fair housing laws do not just apply to you as a real estate agent, it applies to everybody. So it applies to your seller, it applies to your buyer. And there has been suits that have been filed by scorned buyers that basically felt that their protected class, whatever that might have been, was used against them based on a letter that was sent with them. So buyers, a love letter is when a buyer wants to prepare and send along with their offers. And sometimes that includes information about their family, their school they're attending, photos of their family, and all of that can trigger discrimination or allegations of implicit bias in favor of or against the buyer of a protected class. So it is highly recommended from the attorneys at the state level that you encourage a buyer to not use this and to encourage your sellers not to accept them. And if your seller is not going to accept them, you need to explain to them why you're recommending that. And then maybe in your agent notes on MLS that you put in there, seller will not receive any love letters that are presented, and you will not read them as well. So help a buyer find another way to make their offer stand out. If a buyer does insist, have them try to encourage them to limit the information. You get into a really sticky situation when they are going to insist, because you are there to represent the client and do what your client asks you to do, even with the seller, if they want to accept them. So the best thing you can do is, if your buyer is demanding it, ask them to limit the information only to talk about how they can perform, the terms of their offer, to exclude any personal information. If they choose to go ahead and do that, that's on them, but have something in writing. I always recommend just communicating that with a buyer when you're getting into something like this that can really be used against them. Just follow up your conversation in email. Type up an email that says, as we discussed today, I just want to reiterate, if you're going to do this, my recommendation would be to limit your information, and just kind of give it that in writing, so that if it ever comes back to bite them and you're drug into it and the brokerage is drug into that kind of a lawsuit, there is conversation and documentation there that you did ask them to limit and that you did give them advice. If the seller wants to review or accept an offer that has a love letter attached to it, you need to refer them to legal counsel. You need to tell them that they need to document their process of how they're selecting their offer, because if it comes in from somebody that is feeling that they were discriminated against, then that could be the actual thing that helps them in that case, by documenting what their process was in selecting the offer. But it's highly encouraged that you encourage the buyers not to use them and the sellers not to accept them, because it's very easy for a thought to be planted in someone's mind. It is as simple as, oh, I see your son goes to this school or goes to that school, and you have that's your school, so you know your kids go there, and so all of a sudden you have this bond with them, and it's a Catholic school, or it's, you know, something along those lines, and now you've gone in here and you've selected a buyer on the basis of their religion. So those are how quickly those thought processes can get into our heads, and we don't even realize that it's happening. So it's better to not even go down that. Earnest money risks. Remember that that's not required by license law or any law. It's not required that somebody put earnest money down. But it is also, agents are not depositing that money in a timeline that's in the contract. I've had several questions over the last month or so that says, hey, the contract says it's not going to be deposited for 10 days. We just got the inspection back. They're going to cancel it. Do I have to deposit earnest money? Yes, yes, and yes, you have to. It has to go through the process of deposit and release. And there is absolutely no wiggle way around it, and including writing something in the purchase contract. You can't write something in the purchase contract that says if the buyer walks away due to an inspection, they get their earnest money back. Just don't write it. You're practicing law, number one. Number two, once the earnest money, once the contract is terminating, there are rules and regulations that the division requires us to have, and it cannot be done based on what you write in a purchase contract. So do not promise that monies will be returned. That's the biggest thing a new agent will make a mistake of if they haven't learned this. It's not a wise thing to say, hey, you know, if we get in there and there's something majorly wrong, we're going to get your earnest money back. Don't even let those words come out of your mouth, because I've said it 100 times. If you are sitting in a home and the inspection comes back and the inspector says tomorrow this house is going to fall off this cliff, or the next morning after the inspection the house burns down, that does not mean you're getting your earnest money back. And I use those terminologies when I'm meeting with a buyer. It does not mean that they are. Both parties have to agree to have the money released before the money can be released, period. A brokerage is not permitted to release the money from the escrow account unless there is a mutual agreement between parties of where that money is going to go. And if there is not an agreement, then you must have a box on the termination and the mutual release of earnest money that says there is a dispute, because then there are things that the brokerage has to do following that. So make sure that there is a separate written agreement for disbursement. And in our language with where we are, if you are terminating contract, you must use the termination of contract. You cannot just use the mutual release of contract by itself. There's only one occasion that you can use it by itself, and that is if it has nothing to do with the contingencies in the contract. If you are terminating a contract, the termination of contract must be used, and the mutual release of earnest money if there is earnest money. If there's no earnest money, just the termination. If you are terminating because of something that's not a contingency in the contract, then you can use a mutual release by itself. And an example of that would be that both parties mutually agree, because maybe the buyer is being relocated and they didn't know that. So they're both allowing, that has nothing to do with a contingency in the contract. So that is the only time that the mutual release can be used by itself. So just make sure that you're paying attention to that. And if you have any questions about that afterwards, I'll be glad to have a conversation with you, or Ron will be glad to have a conversation with you about that. So make sure you're depositing it in a timely fashion. And if you're using SkySlope here in Ohio, that option is available. If you're in Kentucky, there is a link that the broker there can give you to do that electronically through sending them a link for them to pay it right away. So here, let's talk
Kristen?
about conflicts. Did you have a question?
Well, Jessica does real quick, because it has to do with the deposits. So maybe she just said, how do we handle receiving offers with that wording on it?
Sure. So agents are going to still put it in there, just like they're going to put in as is clauses. My recommendation is to let the other agent know that if that is in there, they do need to understand. And I would say to them, make sure that your buyer understands that if we are accepting this, it doesn't apply. There still is a mutual release that has to be signed, whether you put this wording in there or not. Because some agents don't have anybody that's instructing them that, so they don't know. They think that they're just in there putting this in there. I would scratch it out. If it was me, I would scratch it out and I would just let them know it doesn't apply. And refer them back to their broker, because they're not, it's practicing law when they're putting it in there. And they have to follow the rules of what the brokerage is required to do by law. So it doesn't work. And I would probably inform the other agent that it doesn't work and educate them a little bit on it. And if they want to leave it in, they can leave it in, but it isn't going to get released unless we have a mutual release. And as long as they know that, it's their job to educate their client about it. But at least you've had the conversation. And again, I would put it in writing in an email. Conflicts, how to resolve conflicts. So these are the do's and don'ts that I feel is important. Use proper communication principles. Act in a very positive and patient manner. Focus on the problem and not the person. It's very easy to kind of get caught up in what you're getting and receiving from the other side. So always like kind of focus on what the problem is when there's a conflict in a transaction, and not who's delivering that. Keep a very open mind. Just remember, we're facilitators, not decision makers. And one of the things that's important is that we are able to communicate things to our client. And if we don't have an open mind during that conversation that we're getting, it's going to be very difficult to also turn around and give them recommendations as well. Seek to understand the other person's ideas and points of view. Explore all alternatives for resolving the conflict. So there are some times that conflict cannot be resolved, and unfortunately that does happen, but try to think of all alternatives to it, staying calm and matter of fact about it, no matter what's coming across the other side, and keeping a very positive tone, even though you may not be getting that on the other side, will go a long way into resolving a conflict, especially if a broker has to get involved and there's been a problem. I never want to pick up that phone and have a conversation. Well, your agent said this, or your agent said that. I'd rather it say, be a conversation. Well, they presented this, and that, and it goes a little bit better when we get involved in that. Don't prejudge people. Just because you take a buyer consult or something over the phone, and you never know what that person has, who they're connected to, or if it's a waste of your time. I hear that a lot. Well, I just think it's going to be a waste of my time. Nothing is a waste of your time. And don't prejudge people without knowing what you're dealing with, and treat everyone the same way. Assume that you have all the facts. Don't do that, because you never have all the facts. You will get into transaction and you'll think that the clients were 100% honest with you, and something will come up in title, something will come up in a background, and you'll find out that the facts are not there. So just make sure, don't assume that you have them. Don't focus on the other person's attitude, personality, or presumed motive. A lot of times we find that our client's getting mad at the other client, but they've never spoken to the other client, buyer or seller. And it's always the perception that we're giving them based on what the agent on the other side is giving us. So it could be the agent on the other side that's frustrated, not the actual client that's frustrated. Or sometimes they've never even had the conversation with a client, which is another violation, but you're just assuming, and then you're taking all of that frustration that you're getting and assuming about the buyer or seller, and you're passing that on to your client. That's not a wise thing to do, because then you get them all worked up. And when it comes to the closing table, a lot of times people they don't even have the same perception of what was happening. So focus on how you can resolve something, and not what the personality or presumed motive is of the other person. Don't ignore others' ideas and points of view. I was telling John this morning of a situation, because most of you know I'm a certified coach, but my husband over this weekend, he said we were getting into some kind of conversation about something. And I just said, so I hear you say, and he immediately said, stop coaching me, because but in this situation here, letting them know that you hear them, letting them know that you understand what their point of view is. Doesn't mean that you're going to agree with it and any of that, but always have the understanding that that their points of view and their ideas are valid and that you hear them. Don't overlook the possibility of a different perception, because there are times even now where I have a question, I'll call Ron and say, hey, what's your thought about this? Or I'll call Jeremy, what's your thought about this? And they'll give a different perception than what I'm thinking. And so my thought process will change, and I'll look at the situation a little bit different. So always think about what somebody else's perceptions may be, because it may influence how you can negotiate a transaction during that process. Don't get defensive. It is very, very hard to do that. At times, I would rather you say, if you feel yourself getting to that point, I would rather you say, at this point, I think that we need to step away from the conversation and kind of calm our jets down a little bit. And then we will come back when we both have had a minute to kind of breathe about it. So don't let yourself get caught up in the conversation of defensiveness with them, because it's only going to hurt you and your client. Don't get into the discussion of and be unprepared. So make sure that before you make the call or accept the call, that you are prepared for the call, because if you are not, you will end up getting defensive and you will end up having a more hostile conversation. So make sure you're always prepared for the conversation. Focus on meeting practical needs, and don't focus on the expense of personal needs. So make sure that you're thinking about everything practical and nothing about personal. And that also goes for your commission. Don't be thinking, if I don't get this done, I'm not going to get paid. I know that comes into all of our minds, but if we go that direction, you're going to forget the reason that you're doing your job, and you're going to forget the importance of staying in the present of resolving that conflict, because ultimately you may end up losing it for having that mindset. So make sure that you are thinking about the practical needs of everyone involved. The importance of handling your conflict well is 96% of unhappy clients won't ever complain about you. 90% of unhappy clients won't utilize your services again. But remember, one unhappy client will tell 10 people of their dissatisfaction, and those 10 people will tell another 10 people. So your reputation is one of those things we always talk about our sphere of influence, right? And how we get a client from here. And then we do, that person tells one person, and then all the same thing with when you have something that it goes bad. That sphere of influence starts to shrink, because they're telling people exactly how displeased they are with you as well. Talking about showing properties do and don't. So before you show a property, provide the buyer client with a recap of their needs, wants, and priorities in a checklist format. Provide an advanced list of the homes to give them an opportunity to drive by and check out exterior locations. I always tell people, they're like, I hate the conversation. Is this a good property? Is this in a good location? So my recommendation to buyer is, when you have time, and a couple of years ago, people didn't really have a lot of time, but drive by that property at different times of the day. It's really good to drive by it early in the morning. Who's getting up in the morning? Who's leaving for work? Really good time to drive by at dinner time or right after dinner time. What's going on outside? Are there people outside? Are people enjoying each other and talking to one another? And then drive by it at 2 o'clock in the morning. What's going on at 2 o'clock in the morning? Do you feel good driving through the neighborhood? Those are good ideas to just kind of give them as they're going through the process. Provide a sample purchase contract so buyers can be prepared. When you have your buyer consults, as we talked, you should go line by line through that contract so they understand it. I always tell people it takes a little bit extra time in the beginning. I think our buyer consults that I teach take about an hour and a half when you're really good at them, 2 hours in the beginning. But it's important for people to understand what they're going to be signing and what each clause means, because if you do, it's much easier during a heated negotiation or questions that you can say, remember when we talked about, versus trying to explain it to them when their emotions are a little bit in a different place. So provide that with them. Schedule several hours of showing, make sure arrangements for stopping, rest stops and snacks. Encourage your clients to arrange a babysitter and leave their pets at home. So it's a good idea to have that conversation. Set up expectations for proper behavior. Remember to remind them they're a guest in the home, and that even though they're not supposed to be recorded audioly, by audio, they could be. And they need to not give away their excitement if it's the best home in the world, because they give away their negotiation power, but also not to say something that could hurt the seller as well. Stress the importance of punctuality and explain why. People are, grabbing their animals, taking their kids who could be ill, and putting them in a car for a little over an hour. And we need to make sure that we're respectful of the time that they are away from their home, and recommend setting a time aside after the showings to consider the pros and cons. The only thing I like about HGT and what is those people's names that did those rehabs? I can't even think of their names, but assigning a name for each house is something I do agree with, because they will forget. If they're seeing a ton of homes, they will forget which one is what. So I like to have a notepad or lines on the back of their showing sheet, so that they can actually write the notes down of what they liked and didn't like as they're walking through the home. Arrive on time for showings, wear slip-on shoes. Especially if the seller has a sign or they have something in the showing request, make sure that they understand that that is going to be a requirement, and respect that. Don't take anything that belongs to the owner or damaged property. No loosening carpet. I'm going to tell you, this really does happen. I walked into a showing, and I had to call the listing agent because somebody had literally pulled the carpet back to see if there was wood flooring while I was there. So there were two of us in the property at the same time. So can't do that. Leave the property as you found it: lights, heating, cooling. Unless they tell you to turn out the lights, don't turn out the lights. Also, another thing that you need to think about is ask if it's okay if you leave your card. There have been some complaints filed about an agent leaving cards, and they say that they're soliciting their client and crossing the sign. I know it's been a practice, but it might be a good idea for you to say, hey, is it okay if I leave my card to let you know that I've been there? But those have been complaints, and they are being held up as valid. So just food for thought. Remind buyers that no house is perfect, and to focus on the potentials. Buyers should not feel that they will hurt anyone's feelings if they reject a home. Make sure that they look around the home for surroundings. If you don't smoke or eat in the house, but if you walk into a house and it's been left unlocked, or a key is in the door, or any of those things, make sure you call the agent, let them know immediately, follow up with an email. Nothing happens if it is in writing. So if you go in there and the house has been unlocked, you're going to call the listing agent, you're going to let them know that, but then follow up with an email that just says, hey, just to follow up, I just wanted to let you know in writing that when we walked into the house, this house was not secured. Because if something happens and something is taken, you have given written notice that there was a problem when you arrived. You're protecting yourself, and you're protecting your buyer as well. So do's and don'ts in negotiation. Do thoroughly prep alternatives. Get what you need and leave others satisfied that their needs have also been addressed. Take a balanced win-win approach. See negotiations as competitive but cooperative. So you do need to have a little competitive edge about you, and but be cooperative in the process. Active listening. I teach this a lot in coaching, because there is a difference between active listening and listening. It's kind of like, I use an example of spouses. You'll say something, they don't hear you, right? They aren't actively listening to you, and they may go, uh-huh. It's the same thing. If you're on the other end going, yeah, kind of whatever, then those people aren't going to feel that you're really hearing them. So make sure you are hearing them. Practice thorough goal setting and be rational about it. Maintain your integrity. Use your power, but in moderation. Study limits of others' power. So making sure that you're kind of on the understanding of what they're doing, and if they're kind of pushing you a little bit, kind of understand where they're going. Express your sensitivity to them. Address real issues and problems. Don't get into the little stuff. Make concessions carefully with full knowledge of when and planned. So don't go overboard and concede more than you need to at the moment. Show creativity, give leadership and support, ask probing questions, separate people from your issues. Identify the strategies used against you. Make sure you know when that's happening. Don't get blindsided by it. Update your assessments as you need to, because during a conversation, you're going to find out things and more. You need to update kind of how you're approaching the situation during that time, and use modest theatrics for emphasis and change of pace. I've always told people you need to know how to gasp. You need to know how to do it well, because that in and of itself can be a tool that you can use to get somebody to start questioning themselves if you know how to do it well. So learn how to gasp. Don't feel uncomfortable with conflict. If you are uncomfortable with conflict, you should not be negotiating, and you should not be in this business, because you're going to have conflict, whether it be with an agent or whether it be with someone else. So don't be uncomfortable with that. Don't use excessive lose and win positions. You're in here to both win for both sides. So again, keeping your personality and your personal feelings out of that will benefit you when you're negotiating. Don't threaten or bluff. This is the last one, the last offer we're making. This is the last time that you're going to see that. Make sure it is. Make sure it is, and tell your seller or your buyers. So if I say this, it's the last time. And if they don't want your offer, we're walking away, correct? Because that's my word matters to me. So make sure that you're not just threatening and trying to bluff them, because that doesn't get you a good reputation in the industry anyways. Don't fail to analyze the project's or other goals. So don't think about, or don't forget to think about what their goals are on the other side as well. Negotiate with those who have no authority. Don't do that. If you are sitting there negotiating with someone who has no input into this transaction, then you have no business negotiating with them at all. So don't do that. Don't use excessive use of power. Don't overestimate or underestimate and deal only with facts. Don't miss time concessions. It's important that you understand, in my negotiation class, I talk about this a lot, that you time your concessions that you have to give at the right time, because there are times when it won't matter. There are times when you do it too early and you give away too much, or you don't do it soon enough and you lose the deal. So you need to get really, really good at when to suggest or agree to a concession. Don't give up on unnecessary concessions. I think I said that on the do side too. Don't give them things that they aren't asking for. Don't be perceived as a pushover or an easy mark. Don't use excessive risk taking. You're doing this on behalf of the buyer or seller that you're representing. So don't take risk with their transaction and with their wants and needs. Don't do that. Don't react when you're pressured. Don't see yourself as an adversary rather than a problem solver. So that's what we're here to do, to facilitate the situation and to move things forward. Don't feel that you're being unfairly treated. Again, personal thought process and personal opinion about things. Don't use a take it or leave it attitude. Be consistent or predictable. You do not want to be consistent or predictable when you're negotiating, because then people kind of know where you're coming from, what your next move is going to be. You need to keep a little bit of that competitive atmosphere, being cooperative, but also being able to kind of like, they don't know kind of where you're going to come at next, and kind of surprise them in a positive way. This is really good on concessions. Like, you know, the buyer or seller is willing to concede something and they don't think that, and you kind of know that they're not thinking that, and being able to pull that at the last moment to save a deal, it surprises them, and now everybody's in a good mood. Those are good examples of that. Don't accept authorities without question. So just because someone says, I have the authority to do this, make sure that you're talking to the right person, and question anything that you feel is off. Don't fear about changing your mind. So just because you are in a negotiation and you know, and tell this to your clients too, just because you're going down a path that you think, okay, I'm going to go this route, remember, you have to update your assessment. So if something has happened in that negotiation, that conversation, and you need to stop and think about that because now something has changed, it's okay to do that before something is in writing if the conversation is warranted. Don't take anything personally, and don't feel looking dumb or embarrassed. There is no dumb question. There's only the dumb question, the only dumb question there is the one you don't ask. So just remember that. There's nothing that's dumb, nothing that's going to be embarrassed. It's always important to ask any question or go down a path that you need to go. And if you need assistance, we're all here to help you with that. And don't give long-winded answers. That's a really hard problem with me, as you can tell. So reducing risk practices, counsel your seller about disclosure obligations, residential property disclosure form, talk with them about that, protect your seller, start and a starting point for your buyer, make sure everything is updated. So make sure the property disclosure is updated. If something has happened during the transaction, goes back in the market. I had a call, I don't even know who the call was. It was somebody, I think from the Kemper office. They called and said, hey, they're moving and we pulled the washer out and there was a water leak that was found after when they were moving. They've repaired it, they've done anything. What is our obligation to the buyer? And the obligation is update the property disclosure and have everybody initial that they saw it. Because anything that has now happened, they need to go ahead and disclose. It's a lot of people just let the other agent know and everybody's like, oh, okay, no big deal. Well, what happens if that's Ron and I's favorite words. What happens if a year from now they say, well, you didn't fix this properly. We didn't know about it. It's not on the property disclosure form. And now we've got a bigger problem. So even at the end, when something is discovered and there's a repair or something like that, go ahead and update the property disclosure and have everybody initial that they have read that and acknowledged that so that it's in writing should that ever create a bigger problem down the line. Disclose negative inspection results. Always do that, in my opinion. Don't guess or give an opinion about something you don't know about. Really don't give your opinion at all. Again, we're just there to facilitate the transaction. Always work strictly on facts. Your opinion about something may not be the opinion of someone else. Refer to experts. Stress the importance of inspections. Explain the as-is clause and how we've talked about that. It's not always there. Follow lawful instructions from your client and keep confidential information confidential. And after your termination, so basically it closes or they withdraw, whatever, when you are finished, your confidentiality still applies. You cannot disclose anything that happened in that transaction except for the following. Client permits you to disclose it. Disclosure is required by law or court order. Information becomes already public. The disclosure is necessary to prevent a crime by the client, defend a claim of wrongful conduct, or establish or defend a claim for commission. Those are the only times that you can disclose confidentiality things after a transaction has closed. It still follows you. It's kind of like an attorney or a physician, all of those. It still follows you even after you are finished with that client. So my takeaway is document, document, document. And that's what I've got. Mr. Wayne.
Goodness. So much there, but you know, it's just like I said earlier, it's just so good to hear it again, hear it for the first time, you know, whoever needs something on the call. But so anybody have any questions? Well, we have obviously, like we always say on these calls, this is not just a one-time thing. Like Kristen mentioned, if you have questions or even if it's a specific situation, you know, we all have a manager in the office, but Kristen's always available to, you know, to help with anything as well. So, but anybody have any questions for now?
And anytime you get into a question where you're in the middle of a thing, you know, pick up the phone, call Ron, myself, or Jeremy. I mean, that's what we're here to do as compliance brokers, is to help you navigate that. Back to murder suicide.
Yeah.
That isn't required to disclose. No, it is not. Unless your seller, you have to have the seller's permission to disclose it. And you cannot make that decision for yourself. It is not required, though, to disclose it. I did have one of those. I don't know if any of you have had it before. The spouse kind of passed away in the kitchen, and he didn't want to disclose it. But like I said, the conversation was there are people that have very strong feelings about ghosts, and I mean, I don't believe in them personally, but people have strong feelings about that, and you have to respect that and kind of walk them through that process. I mean, my husband's first wife died of cancer in their home, and when we went to sell it, we disclosed it because it, people have very strong feelings about that, and you just want to make sure that it's the seller's decision and they know the pros and the cons of disclosing that or not disclosing that. Yeah, you let everybody know. That's usually what happens. That's what we tell the sellers is somebody's going to tell them. Somebody is definitely going to tell them. I had another situation where this is when I owned a missing child organization, but I went to sell the house after the fact. Their child was in a downstairs, they were upstairs. Someone broke in and kidnapped and horribly did some stuff to their child. And they were hesitant because this person never was caught, and their child was a preteen, whether or not they should disclose that information. And my suggestion was yes. They had to make the decision, and they did finally agree to disclose it. But if you have a family member that's moving into that home and they have a young teenage daughter who's going to be sleeping in that bedroom, and that person was never caught and that happened, somebody's going to tell them, and then you're going to potentially have a lawsuit, and then it's going to be the judge's decision on whether or not you should do it. I always say never ever get to a situation, and I tell my clients this too, where a judge is making the decision on the intent and what should have happened after the fact. So you just never know where that's going to end at that point. So luckily they disclosed that. But had they not, that could have potentially put someone else in harm's way. And that's kind of how I approach it with them, but it was their decision. They did not have to disclose that information.
Yeah, it's like 90% of what you said today is very, it's very cut and dry. Like there's no, this or that, but like there is no right answer. Like, should we disclose it? Shouldn't we? But it always seems like if it does come back around, then we were hiding something.
Yes.
It's like, well, we just didn't tell you, and then you're battling that. So
and
it's
then you're
still
battling
not,
it,
doesn't make it right or wrong to disclose it, but
correct.
it
And
kind
then
of
you get
plays
into a
it.
whole situation where someone who's not even a party to the transaction's making that decision. And you just don't, you want to always look at the what ifs. It's just better to look at everything that way and button everything up the best that you can. But it's always the client's decision. We cannot make decisions for the client under any circumstances, unless it is breaking the law, and then you need to make a phone call to one of us brokers about that if that's causing you to break the law. But you can also refuse to do something because it is the way you do your business. Buyer consults. I have a buyer consult. I don't show a property without a buyer consult, period. Never have. Taught my agents not to do it for safety reasons and other reasons. But when somebody says to me, well, I want to do it this way for this person, or I want to do it for, you cannot do that. As long your practice and how you do it, the brokerage has rules, the division has rules, and then you can have your own set of rules and how you conduct your business that fall underneath that. And if that's your practice and that's how you do business, then that's how you do business. And I would just keep it very consistent, and treating everyone the exact same way, no matter what.
Perfect. Well, anybody have any other questions? All right. Well, I think we're good. Thank you so much, Kristen.
You're welcome.
As always, excellent stuff. And we will be continuing, I guess, this compliance series, hopefully, if Kristen will do it, into April, May, and June in our next sort of quarter of training sessions. So kind of be on the lookout for, for just additional topics. I know Kristen's got a bunch, so we'll just kind of get through them as the year goes on. So,
My
but
favorite
thank you.
topic.
Yeah, I know. Well, I love it too. It's like, it's not the most exciting.
I was going to be an attorney, just so you all know. I was going to be a defense attorney, and my dad was a pastor. He wouldn't pay for that kind of schooling. If I wanted to be a prosecutor, that was one thing, but not a defense attorney.
Oh, that's great. Well, thank you so much. Thank you everyone for joining. And we'll see you soon.
All right. See ya.
Take care.